The biggest change in cannabis regulation in decades is officially underway. For the first time, state licensed medical marijuana businesses are being recognized under federal law through a new Schedule III framework. This is not full federal legalization. This is not recreational legalization. And this is not a blanket rescheduling of all cannabis. What happened is far more specific. The Department of Justice and DEA issued a final order moving state licensed medical marijuana businesses and certain FDA approved cannabis products from Schedule I to Schedule III. The change became effective on April 28, 2026. I'm Daniel Sabet, CFO at GreenGrowth CPAs, and I've worked with cannabis operators across multiple states on tax planning, compliance, licensing, and financial strategy. This federal change has the potential to completely reshape the economics of medical marijuana businesses. For years, operators have been fighting one major obstacle: 280E. 280E prevented cannabis businesses from deducting normal business expenses such as your payroll, rent, marketing, insurance, and professional fees. As a result, many operators paid effective tax rates exceeding 50%. That burden may now be lifted for qualifying medical operators that complete the federal registration process. The opportunity is significant, but so are the requirements. And the businesses that move first could have a major advantage. Let's talk about who actually qualifies. One of the biggest misconceptions right now is that all cannabis businesses automatically qualify for Schedule III treatment. This is not the case. The current federal order applies specifically to cannabis businesses operating under state medical marijuana licenses. Recreational or adult use operators remain outside the scope of the current order and continue to be treated as Schedule I businesses under federal law. That means a medical cultivator, medical processor, or medical dispensary may qualify. A purely recreational dispensary generally does not. Now, this distinction is extremely important. Many businesses operate under mixed-use licenses, serving both medical and recreational customers. Those operators face a very unique challenge. Federal guidance indicates that mixed-use operators will need to separate medical operations from adult use operations through accounting, record keeping, inventory tracking, and operational controls. Medical activities and recreational activities cannot simply be blended together if the operator intends to take advantage of the Schedule III benefits. For many businesses, this may require separate inventory procedures, separate accounting records, separate sales reporting, separate compliance documentation, and potentially separate corporate structures depending on how future guidance develops. This is where strong financial systems become critical. The operators that already maintain detailed records will have a much easier transition than operators relying on manual processes or incomplete reporting. Now let's talk about the most important deadline. The federal government created an expedited registration process for medical marijuana businesses. Operators have a 60-day window from the effective date of the federal order to submit DEA registration application. That window closes on June 27, 2026. This may be the most important compliance deadline the cannabis industry has ever faced. Now, why, you may ask? This is because operators that file during this expedited period may continue operating under their state licenses while their DEA applications are being reviewed. That creates a tremendous advantage for businesses that act quickly. The DEA registration process is not a simple one-page application. Applicants must provide ownership information, licensing history, criminal history disclosures, operating procedures, inventory controls, security protocols, diversion prevention measures, storage procedures, and other compliance documentation. Operators may also pay annual registration fees. In other words, this is a federal regulation. The government wants detailed operational visibility into how cannabis businesses function. I expect many operators to underestimate the amount of preparation required. The businesses that start gathering documentation today will likely have a much smoother registration process than businesses waiting until the final weeks of the filing window. This also creates a potentially massive financial opportunity. Qualifying medical operators that successfully register may finally gain relief from 280 restrictions, allowing deductions for ordinary business expenses that have been unavailable for years. For many businesses, that could mean hundreds of thousands or even millions of dollars in annual tax savings. This is one of the biggest economic changes the cannabis industry has ever seen. Now let's discuss what happens next. While medical operators have already been addressed under the current order, the broader question remains unresolved. What about recreational cannabis? The DEA has scheduled an expedited hearing beginning June 29, 2026 to consider broader rescheduling of marijuana beyond state medical programs. The hearing is expected to conclude by July 15, 2026. This hearing could determine the future of adult use cannabis under federal law. If broader rescheduling ultimately occurs, the implications would be enormous. Adult use operators could potentially receive similar tax treatment. Additional research opportunities could emerge. Financial institutions may become more comfortable serving cannabis businesses. Investment activity could increase substantially. However, none of that has happened yet. For now, the opportunity is focused primarily on medical operators. The businesses that should be taking action immediately are medical cultivators, processors, dispensaries, and mixed-use operators that maintain medical licenses. Those businesses should be reviewing registration requirements, evaluating their accounting systems, organizing compliance documentation, and working with their legal and tax advisors immediately. The next 60 days may determine which operators receive the benefits of federal recognition and which operators are left behind. For years, the cannabis industry has talked about rescheduling. Now it's finally here. This is not for everyone. Not yet. But for medical marijuana operators, this could be the beginning of a completely different industry. The operators that prepare early will be positioned to benefit the most. Thank you for watching. Stay sharp.